Alright, we are on part 2 of reading this amazing article from the Mothers Movement. Why am I doing this to myself? The problem with presumptive joint custody. If presented without supporting information about the complexities that can factor into divorce, joint or shared custody sounds like the reasonable, fair way to go. Yes, it's appealing even to those who comprehend the vagaries of warfare between divorcing couples. Trish Wilson, in her article, Solomon's Solution, references New York Judge Felicia K. Shea's explanation about why judges might lean toward this arrangement. Shea writes that joint custody is an appealing concept. It permits the court to escape an agonizing choice, to keep from wounding the self-esteem of either parent, and to avoid the appearance of discrimination between the sexes. Shared custody agreements imply that two parents are contributing equally toward their children's stability. For such a measure to work, there must be a tacit implication of underlying goodwill. In many of the cases that moved father rights advocates to lobby for shared custody, any traces of goodwill had long since disintegrated. So again, I think this mother is confused and thinks that fathers' rights groups are advocating for fathers to retain sole rights over the children, and it's not. Fathers' rights groups are simply advocating for fathers' rights to be as recognized and seen as important as a mother's rights. Again, that's what it means. And I also resent the presumption of joint custody being related to King Solomon. If you are not familiar with King Solomon's original solution, like the story of King Solomon, a couple was fighting over a baby, and so his solution was to rip the baby in half. That is literally not what is happening when two parents share custody. It may be hard for a child of divorce. It may feel like their heart is being ripped in half, but that's going to happen no matter what when a child's parents split up. The solution is not one parent gets more rights over the other. Joint custody is still, as this author mentioned at the very beginning of her own article, the best case scenario. According to experts, parents that choose to share custody make it work well. Wilson points out that early studies of joint custody reveal situations ideal to making it work well included cooperative relationships between the parents, financial stability, the mothers not having remarried, mutual agreements to live in close proximity to one another, and the fact that these couples usually had one child. However, studies also showed that when parental conflict endured, joint custody often elongated the period of dissension and conflict. It's interesting that they point out that it works better if the mother doesn't remarry. Like, it's not a problem if the dad remarries. Are stepdads more of an issue than stepmoms? I will say stepdads murder biological fathers more often than stepmoms murder biological mothers. That's just a fact. Maybe that's what they're referencing. A weird thing to throw in there, though. Judith Wallerstein, author of many longitudinal studies on divorce, including the book Second Chances, declares that strife between adults can be turned toward the children when a contentious divorce is in the works, and that in these cases, shared custody can be damaging. Conflict is bad for children, and if you put them more in the middle, it's bad. There is, in fact, a lot of evidence for the idea that different custody models are suitable for different families. No single formula determines the best match for all families. Wallerstein's long-range study indicates that children in joint custody situations did no better than those in sole custody. Her study also showed that the well-being of the parents had more to do with how well the children fared than how custody was resolved, which would indicate that flexibility designing custody on case-by-case basis helped children to thrive after their parents' divorces. So I want to point out, this is one person's study, and in this one study, it has been asserted that sometimes joint custody is bad. No one's argued that. No one is arguing that sometimes joint custody is not the perfect solution. No one is saying slap this on every single case no matter what. This also does not regard the 28-page study that was put out by the Department of Education, wherein dozens of studies were compiled and put together, and all of them overwhelmingly showed that joint and shared parenting is more beneficial overall. Eleanor Maccabee and Robert Mnookin, co-authors of Dividing the Child, describe a phenomenon that they believe backfired. A study of California courts looked at the outcomes of joint custody being awarded in an attempt by the judge for families to resolve familial conflicts. 3.5 years after separation, these couples were experiencing considerably more conflict and less cooperative parenting than were for couples for whom joint custody was the first choice of each parent. In their study, only 6% of those seeking divorce opted for joint custody. The courts themselves do not keep statistics about how many divorces with children are contested. Jeff Wolf points out that the number of cases filed as contested wouldn't offer complete clarification. Determining whether a given case is contested on custody would be something of a challenge anyway, because someone, a researcher presumably, would have to assess each case to determine the nature and extent of the contest. In its testimony to the California Judicial Committee, the Legal Services Family Law Task Force argued that the poor results reflected in Maccabee and Mnookin's study revealed that the law had not served its intended purpose. The state repealed its law, forcing presumption of shared custody for couples in opposition to trying it. Wow, so in California, joint custody is no longer assumed because of this case, because of one case that, again, the results simply say that it doesn't always work, which we all knew, even though the Department of Education has a much larger compilation of studies that show that it is better. In most cases, California decided to just completely do away with presumed joint custody, if ever one side is against it. Well, then just get rid of joint custody because someone's going to be against it. Most custody situations are settled outside of the courtroom. So by the time it's made it to the courtroom, of course someone is contesting it. This is why we need reasonable judges who follow 28 pages of research provided by the Department of Education as opposed to one study that someone did that does not discount the validity of joint custody, to look at these cases and say, well, it doesn't matter that you disagree because this is what's best for your child. I'm sorry, but mother knows best is not the law. That's just something that people say sometimes to justify why they can't come up with an actual logical reason for what they're doing. Or to give themselves this super egotistical God complex that they somehow, because they're a biological woman parent of the child and not the biological father parent of the child, that they just know best, better than the father, better than the judges, better than 28 pages of research compiled by the Department of Education, apparently. In an editorial for the Voicemail newsletter, Rob Akun, co-director of the Men's Resource Center for Western Massachusetts, Becky Lockwood, director for Crisis Services and Violence Protection at the Every Woman Center at the University of Massachusetts, and Marion Kent, director of Safe Passage, weigh in on the 2004 Massachusetts referendum. They write, on their surface, the questions are simple, feel-good initiatives, but they're not. In reality, they may be seen as a planned effort to undermine current custody laws. With far-reaching implications, the proposed laws could have painful and even dangerous consequences for children caught in the middle of high-conflict divorce cases, and, in particular, in cases where domestic violence is a factor. The author points out that the only rights the initiative creates or enhances are those of non-custodial parents. In what we can only hope was a glaring oversight, the language of the initiative makes no explicit provision for dealing with cases where sexual abuse or domestic violence is a factor. Yes, they do. They literally do. This author herself at the beginning of this made it very clear that the joint custody is only presumed outside of abusive situations. No one wants a child to go with an abuser. That's why at the very beginning of this article, even you said that no one wants them to go to an abuser. There are very clear provisions. You just mentioned them. Jay Silverman, Assistant Professor of Society, Human Development, and Health, and Director of Violence Prevention Programs at the Harvard School of Public Health, has been studying how women in battered situations fail to be protected by the Massachusetts court in custody disputes. He and his collaborators placed these domestic decisions into an internal framework, citing the UN Declaration on the Elimination of Violence Against Women call for the rights to due diligence, as well as the best interests of the child, as defined by the Convention on the Rights of the Child, according to the researchers. The right to freedom from violence is one of the most fundamental human rights. Without that right, all other rights are meaningless. Yeah, That's why they literally wrote in abuse as a valid provision for joint custody not being assumed. But what we're not going to do is assume that all fathers are abusive. That's not going to help either. Family court cases are closed and records that would offer hard numeric evidence are not kept, even state by state. As a result, most evidence is anecdotal. Statistics about violence within families are sobering. 40 to 70% of children of battered women are directly abused by their mother's batterer. Half of child homicides are committed by males within the family circle. Male partners commit half of all murders against women. All right, let me stop this for a second. They're using really big numbers to scare mothers into thinking that it is very likely that their child will be abused by a man if their child has more time with a man. This is not 40 to 70% of children are being beaten. This is if the mom is being beaten, the children are also probably being beaten. That doesn't mean that most men are batterers, not by a long shot. Bringing up child homicide, again, they're the ones saying that it's a silly, crazy antic for a man to dress up as Batman and hang a banner off a building, yet you're literally saying that shared parenting is bad because some men are murderers. Which of those two is more extreme, do you think? According to Silverman and Lundy Bancroft, co-authors of The Batterer as Parent, male abusers are more likely to seek custody than non-abusers. What's more, studies confirm that they are likely to prevail. 48 states, including Massachusetts, have laws requiring judges to assign custody to the non-abusive parent, although judges can override them. In an article for the Harvard Public Health Review, Silverman is quoted, "U.S. courts remain incredibly reluctant to punish men for crimes against their families. In this country, family violence is still seen as a private matter. The value of protecting familial privacy has overridden the value of protecting women from violence." I'm sorry, but are you making the claim that more abusive fathers go for custody than non-abusive fathers do? You're trying to tell me that the majority of men going into court and fighting for their children are abusers. That the majority of men who are fighting for equal custody for their children are only doing it weaponized against the woman. They're only doing it to hurt the women. You're trying to tell me that the majority of men only want to see their children, only want to be involved in their children's lives to hurt their ex. That's what you want people to believe. Oh, but Batman's crazy. Dressing up like Batman is crazy. In Solomon's Solution, Trish Wilson offers an example of this. Oh, great! An anecdotal example. Something that she literally just said was not appropriate to use for the father's rights movement. Literally just moments ago, she was like, oh, the father's rights uses these anecdotal scary stories that are supposed to make us think that mothers are actually keeping their kids from the fathers. Oh, but now we're going to hear an anecdotal story about why split custody is bad, and we're supposed to just listen to it. Okay, let's just listen to it. Angela was divorced from an abusive ex-husband who told her if she tried to divorce him, he'd do anything to prove her an unfit mother and to take the children from her. Placing her trust in the court system's ability to protect her and her children from an abusive man, she proceeded to file for divorce. She was rudely surprised. I was pressured to accept an unstable and unsafe 50-50 custody schedule, even for my nursing infant, she said. I was blamed for the violence in the house, for mine and my children's reasonable fears about their father's abuse. The court implied that if I didn't agree to share physical custody, I would be punished by having sole custody awarded to the children's father. His verbal abuse of me and the children were deemed communication problems. Incidents of child abuse and physical domestic violence were minimized and called a difference in parenting styles. Look, if men really are abusive, and I know that these situations do happen, I do know that women are placed into these situations. I know that the system fails both men and women. However, the author of this article needs to remain intellectually consistent. If a man telling you a story where he was perfectly fit, but the mother took his children, fled the state, caused him this pain and agony of not knowing where his children were to a point that he has to hire private investigators to even find out where his children are, if that is too anecdotal of a story for you to listen to father's rights and to understand why presumption of joint custody might be important, you have to then also understand that this woman's anecdotal story of her ex being too abusive to raise the children also is not enough to strip good fathers of their right to equal custody and to strip children of their rights to having two equal parents. That's the most important thing. Ideally, and you said this at the beginning, author of this article, ideally children have both equal parents. Now I gotta say, y'all can tell I'm already riled up. I may not be ready for this next page because it is called The Invention of Parental Alienation Syndrome. I have a feeling that it is not going to simply be the origin story of parental alienation syndrome, in which it was first discovered and given a name. I have a feeling that it's about to be the complete invalidation of this very real phenomenon that is ruining children and fathers. And sometimes mothers. Fathers can be guilty of it too. I definitely gonna take a little break, drink a little bit of tea, calm myself before this next one. So we're gonna get into the next part, and it's gonna be bad. But if you are brave enough to soldier through it with me, it's coming. Until soon, bye.